If the roadway is a substantial factor in causing the collision or making the collision worse and causing further injuries or death, then you should make a claim against the public entity.
What if you're injured because of a hazard in the roadway? We're going to talk to attorney Claude Wyle about that on today's Ask the Lawyer. Claude, thanks for joining us.
Thank you so much for having me, Molly. I'm happy to be here.
So first off, can you help us understand what a dangerous condition of public property actually is?
Okay, the dangerous condition of public property is the legal definition of what could be a lot of things. Dangerous intersection, a crack in the road, improperly striped road, a bad shoulder, a bad guardrail. These things all come under the umbrella of dangerous intersection of public property, and that is the title of the code that gives you the ability to sue a public entity for a dangerous condition of public property in California.
How much time does somebody have to file a suit after they've been injured? And does that timeline change if the defendant is the government?
Normally in California, you have 2 years from being injured from the event to file a lawsuit before the statute of limitations runs out. But if you believe that a party, such as a city, county, or the state, is partially at fault or all at fault for your injuries, you have 6 months within which to file a claim. And that's not a lawsuit. First, you have to file a claim, then the claim has to get rejected, and then you get to file your lawsuit. But if they don't reject your claim, you have to file your lawsuit within 2 years, just like you were suing anybody else. Once they do reject your lawsuit, though, you only have 6 months. So conceivably, a case against a public entity, if you file it right at the 6-month deadline, if you file your claim and then they turn you down right away, conceivably you could end up around 1 year as opposed to 2 years. So it's very tricky. You better know these deadlines or it's kind of a mind trap.
Yeah, you don't want to miss the deadline for sure. Does a roadway hazard have to be accidental? What if the design itself actually created the danger?
Well, there's something called design immunity. There are many kinds of immunities for public entity cases. I mean, think about it. You're only allowed to sue the public entity if it's created by statute. It's not created by just, oh, it's a tort, they did wrong, therefore you get to sue them. It has to be under certain conditions for certain things that the public entity has done. So if they're making the rules, if they're writing the statute, they're going to make the rules and the statutes to benefit them, and your lawyer better know exactly how to fit within all the deadlines, how to navigate through all the immunities. And still, when you're doing your best to navigate through all the immunities, sometimes you just get caught because there's always room to argue within the law.
Can the successful prosecution of these cases help the public at large?
Very much so. We strongly believe that without accountability, you can't effectuate any really good change. And that also is applied to public entities. Public entities, I think, mean well. They try to do well, but you have to really hold them to their own rules. And you have to make claims when somebody's injured because of a dangerous condition of public property. If you don't make a claim, if you don't report what is going on with this roadway, with this intersection, with this bent guardrail, then they don't have to do anything because they have to be notified of the dangerous condition of public property in order to be obligated to fix it. So one way they get notified is through accidents, and the accident data goes through the CHP, the California Highway Patrol, or the police departments, and that's one way they get notified. But another way they get notified is through claims. So if people are making claims or sending in letters that, or even emails that this dangerous condition exists, then the public entity knows that it has to make it safer. If they have no notice, they don't have to change the condition. So a condition can be dangerous. And this goes back to your last question. Can the design be enough? Does it have to be accidental? Yes, the design can be enough. There's something called design immunity. However, and this is probably the biggest exception, if the conditions have changed over time, including if there are a lot of accidents at a certain location, the public entity must take a really good hard look and try to determine how do we make this roadway safer. Because it's not just black or white, one driver versus another driver always. Sometimes the other driver's at fault, but the plaintiff is a little bit at fault. Sometimes the other driver's at fault, the plaintiff's a little bit at fault, and the roadway is a player in causing the collision. If the roadway is a substantial factor in causing the collision or making the collision worse and causing further injuries or death, then you should make a claim against the public entity. And if you don't make a claim, the public entity on the next one can say, we had no idea this was a dangerous roadway. So we always feel that it's important to at least make a claim whenever you think there's a dangerous condition of public property that you encounter on the roadway.
Now, Claude, you spoke about how important it is to know those deadlines, for your attorney to know the deadlines, but what important aspects of a dangerous condition case might be overlooked by a less experienced attorney?
Well, the claim statute is complicated. I was actually just working with a lawyer who is a few years my senior and who used to work at Caltrans Legal defending the state. And we had a little argument about what the deadline was in our case because it's so complicated and depending on the facts. I whipped out the law on my computer and showed him, and he was like, wow, okay. And I couldn't believe that I actually knew the law better, at least in this one instance, than a gentleman who's been doing public entity law for his whole career. So you really have to go deep into this area of law. You can't dabble in it or you're going to get caught in one of the minefields and your whole case can go down the tubes.
Absolutely. Claude, valuable information. Nice to see you. Thanks for joining us today.
Molly, it's so good to see you, and I really appreciate it. Anytime you guys want to ask me anything, I am here.
Thank you so much. And that's going to do it for this episode of Ask the Lawyer. My guest has been attorney Claude Wyle. If you'd like to ask him about your situation, call the number on the screen. Thanks for watching. I'm Molly Hendrickson for Ask the Lawyers.